Thank you, Mr. Gapes. It's a pleasure to serve under you. And I come at this because, as people may know, I'm Vice Chair of the All-Party Parliamentary Group on the Loan Charge. And I was approached by an agency that employs health workers, doctors, nurses and healthcare assistants purely for the NHS. And there's an interconnection with the loan charge. And of course, it's because of the unintended consequences of IR35's creation that we've had the whole problem with the loan charge, because it was loan schemes were set up as a way of enabling people who are self-employed and freelancers to not be disbenefited and end up having to pay more tax than if they'd gone through PAYE, and also for many of them, it was to remove the administrative burden of setting up their own companies. And as the debate that is going on now in the main chamber will express lots of examples from many members from across the House, there have been many very distressing consequences of the loan charge in the way that that's been handled, particularly in the last 3 or 4 years by HMRC. But I want to just relay the concerns of this managing director, owner and founder of what was a significant recruiter of NHS workers, but whose business has declined by over 60% in recent years. Now, the particular issue he has concerns with, and I hope I can express it clearly, and I apologise if I don't get this entirely right, but his particular concern is the confusion within the NHS about whether freelance workers are subject, are PAYE or not. And there is a mixed communication. And this is causing him difficulty in his business, but of course it's causing difficulty for the workers concerned. Now, we're talking about people who are low paid or just about medium paid, or some below 30,000, most below 50,000 per annum. These are people who, because of often the inflexibility of NHS employment, choose to work on a freelance basis day by day. That means they could be, London-based people could be sent to Southampton one day, Bath the next day, maybe somewhere in London the next day. They incur travel expenses. They incur, for long days, they incur costs that in a normal sense would be able to be claimable against the company. But if they're PAYE, they cannot claim these costs. So they have stopped. So therefore, they make themselves unavailable to the NHS. And what I've also learning is that this is one of the major causes, that plus Brexit, of chronic shortages of freelance, of staff, of clinicians and medical staff, nurses and nursing assistants in the NHS, because it's just not worth people's while who need to work flexibly, but are being forced to go through PAYE, where it's just not worthwhile. So what people are doing is working in the private sector, private health sector, where there's more flexibility, where these restrictions don't apply, or they're leaving the country, or they're leaving health and working in another sector where they're better off, or in a sector which is more able to be flexible. So what I've been told is that 99% of this firm's agency workers are being unlawfully blanket assessed inside IR35 and forced into unlawful employment without a fair assessment. Approved NHS framework operators are enforcing these blanket assessments. NHS Improvement have stated a fair and individual IR35 assessment must be carried out, but this is not happening, and blanket assessments are uncompliant with the legislation. The fee payer, under the new rules, the 1917 Finance Act, the agency or third party paying the workers, PSC, are not being allowed to carry out an IR35 status assessment to determine the proper IR35 status of the work. I do apologise for reading this, but I'll get it wrong if I don't. The fee payer is the closest party in the contractual claim chain to the workers' personal services company. This is despite HMRC guidance, which states, quote, where a public authority, agency or third party, quote, the fee payer, makes a payment to a worker's intermediary on or after 6th of April 2017, it decides, the third party decides, if the rules apply, and then deduct tax and primary NICs from the payment it makes, and pays the employer's NICs, and is included for calculating the apprenticeship levy. So the HMRC check employment status tool used to assess workers assumes mutuality of obligation, one of the main tests that has to be assessed for IR35 determinations, has to assess in all engagements. So as a result of the assumption, the CESS tool is flawed. The importance of mutuality of obligation can be demonstrated in the recent tribunal case, Narayan against community-based care health. The details I can make available. So personnel, supply of people to NHS trusts, it appears there's no mutuality of obligation. The worker can cancel a shift at any time and will not be paid. And this is key to that case. The NHS trust can cancel a shift at any time and the worker will not be paid. This is also confirmed in this company's contracts, the agency's contracts. However, 99% of the agency workers are blanket assessed inside IR35 and forced into unlawful employment. It appears that HMRC doesn't understand the IR35 rules itself. There's a recent tax case that HMRC lost with Lorraine Kelly, apparently. Now, if HMRC are losing IR35 tax cases and have lost approximately 50% of IR35 cases that HMRC brought against contractors, how can they implement an online tool to get a correct IR35 result when they can only get it right, HMRC can only get it right 50% of the time when they go to court? This has to be worrying. Now, I am very concerned with what I'm hearing from this agency, who's trying to do the right thing, and incidentally warns all the agency staff that they employ off the loan charge, is an umbrella, is an umbrella company, but does not use the loan charge. But it's therefore, you know, I'm absolutely convinced that this company is trying to do the right thing, but is really, really concerned because of the impact that this confusion between HMRC and the NHS is having on the ability to provide a supply of appropriately qualified and available staff to the NHS as and when needed. Thank you.